What's going on, guys, and welcome back to another one. Today's video is going to be about, well, it's not going to be about a lot. So, usually we have some kind of prompt or something we have to talk about for what we have to do in our content during the week, but this week we were kind of just told, chat about the notes. And, we only had one chapter to read, and we only had one class this week, so I really don't have much to talk about. I'm going to try and stretch 5 minutes worth of content out of it, but this is the first time I'm doing a video totally unscripted and honestly kind of having no idea what to talk about other than reading off my trusty notes, which I have right here. So that's what I'm going to do. Anyways, let me get into the quick little bit first, and then, we'll talk about it. So, as you know, now 97% of my viewers aren't actually subscribed. Used to be 95, but more people are watching, and fun fact, nobody's subscribing. I even got comments from random people on a couple of my videos, and yet they haven't subscribed to the channel, despite my constant recommendations. So please, if you have a minute, could you do me a favor? Like the video, subscribe, and comment something down below, and actually, do the subscribe bit this time. I really appreciate it. Anyways, back to the video. So, this week, we talked about analyzing statutes. Now, what does not aid me in trying to do an unscripted and, fun video like this is, my notes are a mess. They are like a jumble of shit everywhere. So I'm going to try and, have some kind of order to it, and that's going to lead to me jumping around and sounding like a moron. But, what else is new? Anyways, so, our goal when analyzing statutes, which if I didn't mention before, was the topic of this week, is to extract the law underlining the statute. When you're reading it, you want to find out what law is used in this statute and how you could use this in your case. Now, there is no one answer to a case and, etc., the law and all that. However, you have to convince the judge that what you're saying is the only answer. Not just the answer, but the only possible answer. You have to be prepared to argue this side of your case, even if you don't believe in it. I've said it a million times. Argue like you're gonna die if you don't, because it's so important. Per curiam is a decision made by the court, but without a name. So, if it's like a super controversial decision from like a certain judge or whatever, if it's about something that they think might get a lot of backlash or could even put a judge in danger, potentially, they'll leave a name off of the decision just for the sake of safety and, not ruining someone's potential career, because there are hard decisions that need to be made over controversial topics all the time, actually. So we have to try to stay away from absurd policy results when we're analyzing these statutes, and, when they're making the statutes even, they also have to do their best to stay away from making a statute that could result in something weird happening, So, when we're analyzing them, our goal is to find out another goal, not just our goal. Everything's our goal. I don't know. Find out why the policy was created and use that to bolster our argument. If you know why they made the policy, you could use that to make your argument based on the policy even better, because you could use your case as an example on why it was made. I think my mic's really quiet, but I'm pretty deep into this video, so we're going to worry about that later. Anyways, so most public opinions are appellate cases. I'm just going to throw that little nugget of information out there in case we need it. Now, for the rest of the video, I'm going to be talking about procedural history. And, no, I'm not. I'm going to be talking about how a legal proceeding happens. So, the different sections are procedural history, which goes over the previous legal processes that already happened. You have the question that's presented, the question asked by the appellate that the court must form an answer to of some sort. You have to choose. Okay, so this is me, an example of my jumble of of notes. So when you're applying a statute, you have to choose the version of that rule that best fits your case, and again, make it seem like it's the only possible choice. So, if there is no rule, you have to use the context of the case to almost make a rule. You have to essentially tell the judge what the rule should be, and, pray to whatever God you believe in that it'll work. So holding is the decision, and everything that comes with the decision, the reasoning and everything. I literally wrote the decision and all that like an idiot. Obiter dictum is non-binding words in the opinion, essentially irrelevant stuff to the actual ruling, but could come in handy for understanding, the reasoning and in potential future cases. Disposition, when it's affirmed, the lower court is always right, essentially. If it's reversed, that means the lower court was wrong and the higher court was right. If it's remanded, they send it back down to the lower court to try again. A dissent is when a judge or like a member of a whatever bench, sorry, lost the word, disagrees with the reasoning, and lawyers will use that reasoning later to try and argue different types of cases and different kinds of points of view. That's kind of all I got today. So, sorry for the, random kind of shit video this week, but I promise you next week will be a lot better. I'm going to devote a lot more time to it, going to actually write a script, and hopefully we have a prompt which will be a lot better. So, thank you for watching this far. If you stayed for the full 6 minutes, which probably nobody has, if you have, please leave a like on the video if you liked me rambling about basically nothing. Comment down below, call me an idiot, or say something nice. I don't care. Subscribe to the channel. Thanks, and I'll see you in the next one.